Welcome to all participants connected today from the entire planet for this absolutely exceptional global digital encounter dedicated to a topic that is at the heart of our present, but above all at the heart of our future. So as such, we will try to discuss how generative languages that AI, that artificial intelligence permit, completely change the face of issues connected to intellectual property and far beyond. For this, we think that there is a large avenue for debates, for discussion, but also for better understanding and knowledge of a topic that is being shaped now. It is the duty of the global digital encounters to take care of this super important issue and to invite among the most authoritative experts of this planet in this very topic, our two colleagues, Professor Carmelo Fontana from Bocconi University and Professor Thomas Margoni from Leuven University. Both of them, in various capacities and in many, many different formats, have a huge experience in this very topic. They will be moderated by my colleague and friend, the coordinator, under the co-direction of Professor Manuel and myself, of Professor DESANTES and myself, of these global digital encounters. So we are absolutely enchanted to have Javier FERNÁNDEZ-LASQUETTY, professor at IE Madrid, also the moderator today of this global digital encounter on a field on which he specializes as well. I wouldn't wish to take too much time. I would wish again to thank all our audience from all continents. I remind that when the Transatlantic IP Academy and FIDE Foundation embarked in this project more than 3 years ago of create pro bono global digital encounters on how the IP system will be reshaped during, after COVID in a new world, we were going into an unknown process. After 3 years of experience, we have a regular audience connected now, audience that will watch this global digital encounter and read the report that will be published in a few days and will be prepared by one of our large team of PhD candidates who support this activity. So I really wish to thank also all those who from external sources support the global digital encounters, and again wish a successful and fruitful meeting. I remind all of you as well, for participants, that you are able to raise questions in the chat and that these questions will be handled by our speakers and moderator. And if time doesn't allow to handle all questions, written replies will also be published later. So again, greetings to all for this new start of the year, the academic year, and I wish you a big success for today's conference. I would wish to give the floor right away to Javier FERNÁNDEZ-LASQUETTY without delaying, and Professor Manuel DESANTES, my co-director of this activity, will close the session and announce our next scenarios. All the very best to all, and thank you.
Thank you. Thank you, Laurent, and thank you, Manuel, and thank you to Carmelo and Thomas for being here with me. It's a real pleasure and an honor to moderate this session and for that so interesting topic. I tend to go to the past and try to look for some information that could be useful in order to attend new challenges and new things that may happen. And well, it is true that we have in FIDE we have been studying questions about AI from some 7-8 years ago, and it's also true that we had a congress about AI and IP. We in 2019 it was called a dialogue between AI and IP. And also I found some interesting pieces of information produced by AI PPI, etc., also in 2019. But when you face the current situation, you will see that the AI we are talking about is quite different than the one that we were studying on 2015, 16, etc., and so on and so forth. And LLMs have changed this environment a lot, and are creating lots of concern in different areas, not only IP but also personality rights, data protection, etc., etc., etc. But today we will concentrate on questions regarding IP, regarding copyright, and these special AI that is that are the LLMs. And we have discussed the possible topics. It wouldn't be possible to us to talk about everything, and we will try to have a fluent conversation about some of the issues that have been raised by this new technology. And one of the issues that is in the mind of everybody because of the discussions we had is whether or not there is any copyright in the LLMs. The question of the authorship, the Davos case, the question of Castanova case, and the decisions of the U.S. Copyright Office. Just some 2 days ago, the U.S. Copyright Office issued a decision about whether or not it was possible to claim copyright over a work created using an LLM, and the decision doesn't move so much from the decisions they had before. They open sometimes the possibility of having some copyrighted work, but there are still things to be fixed, to be solved. So, Thomas, for instance, what do you think about this? Is there any copyright? Could it be possible to find copyright in the LLM's output, considering the human intervention that is always needed to be found in that type of machines, let's say? Thomas or Carmelo, whenever
Thank you.
Yeah, Thomas, go ahead. Yeah.
Thank you, Javier. Thank you very much. First of all, a very brief but obligatory thanks to you, to Laurent, and to Manuel, and to the organizer of this great series of events. It's really a pleasure to be here together with Carmelo. Regarding your question, I think that honestly is more of a question for technologists than for lawyers. And by that, I mean that the law, to me, has been clear since, I would say, if I go backwards with my memory, 1984, when to my recollection suggests me that Pamela Samuelson was one of the first in writing about computer-generated works back in that time. And the theoretical framework, to me, to a good extent, resists. If the work is computer generated, there is no copyright. There is no almost, and maybe here we can make a small precision, but almost no copyright tradition, even before the copyright law, that has ever, considered attributing copyright to non-humans. There may be many reasons for this, some more philosophical, some more historical. Never before in the history of humankind, or at least in the history of copyright, we have faced this problem. But in many of our traditions, there are clear elements of human ingenuity in the creation. A different thing is that of computer-assisted works, or, nowadays we would say in situations where the AI assists in the creation. So it's not a properly, so to speak, a defined case of artificial creation. Well, in those cases, I think that traditional copyright rules are likewise clear. If there is an element of human ingenuity, that element attracts copyright protection. The element that is contributed by the AI does not. And I think that the decisions, the US decision that you mentioned, more or less are along this line. Obviously, the situation could be, from a normative point of view, different in the future. Should we decide that the law should change, that there is a need in the market, in the technological sector, to recognize copyright or other rights in works that are entirely computer generated. But again, this is more of a normative question, a question of what kind of society do we envision, rather than a question of what is the current applicable law.
Yeah, wonderful. Thank you. Something if we have time, we will discuss at the end of the session. That is, will the machine replace the humans, and do we need a legal environment for the machines creating things? But let's go step by step. Carmelo, what do you think about this?
In general, I have to agree with everything that Thomas said. I think ultimately the situation, the conclusion on whether or not a work that has been created through the assistance of an AI algorithm could be copyrightable or not, it largely depends on how the technology is used. When I have to explain that the different degrees in which a human contribution to the process makes a difference, I use the example of the monkey selfie. You all know the case, and they say if the photographer, David Slater, I recall it was called, if he had put a banana on top of the camera and that attracted in that way the monkey, so that he had envisioned a process, and the ultimate output was part of that calculation, you can pin the human intervention to that calculation, to that design, to that multiple different alignment of steps, that whether or not they occurred in the mind of the photographer, or you could argue in the mind of a machine. If you wanted that to happen, then you would have a copyrightable work because you envisioned and you anticipated that process. Then there are things that would need to be seen in practice. If you had a text and you as a prompt, you ask the algorithm to translate it into another language, there would be no issue on the IP status of that translation. What instead of translating into another language, you ask to translate into another form? So you have bullet points and you ask to create a paragraph. What if instead of bullet points into a paragraph, you ask to create a formal, very professional letter? And then what if you want to create for each paragraph of the letter a more expanded chapter of what would be a memo or a report? I mean, you see where I'm going. If that's intentional, and you start recognizing the red thread that goes through the different prompts that the human is providing to the machine, that would be the participation, the required human intervention that would create a copyrightable work. The issue is ultimately going to be whether or not this is responsive to the rationale of copyright. If it's going to incentivize creation, creativity, and protect culture or not. And in this sense, it would largely depend on how people would use the technology and what would be the commercial status of all of this output.
Yeah, right. I share most of your ideas. I'm really concerned because of the recent decisions taken by U.S. Copyright Office and other offices, etc. Because, but let's go step by step. I think that the technology currently is quite different and is creating some other different scenarios to be considered. I mean, I remember we studied this question of copyrightable subject matter and artificial intelligence in AI PPI. And at that time, it was 2018, more or less, it was decided that there could be three types of intervention of human beings. First, in the selection of data. The second one, intervention while the machine is doing something. And third, intervention or decision about the output. And there was a lots of combinations, etc. You can imagine the enormous number of combinations, but we had at least some elements to be considered, etc. But currently, the situation has changed because, well, as far as I know, the LLMs doesn't allow you to decide the data that could be used. I mean, it's the machine that already has loaded all the data that are coming from all over the world, and takes, let's say, that takes its own decisions. And obviously, there is no human intervention. And well, you can select the output. That's the only thing that you can do. I mean, and you even can change these by using, if it's a painting or photograph, something like this, you can use Photoshop or something like this. And the question currently is about the prompts. I mean, how long the prompts should be. I mean, how far the programmer, let's say, has to go. And the recent decision from the U.S. Copyright Office is very restrictive on this, because they have said that the mere set of indications, etc., is not sufficient to consider that there is an enough human intervention. Okay, so where is this? Where are we? Where are we going? Do we have to create something that will be different in order to give an answer to this new type of, let's say, creation? Do we have to stay where we are and not consider that there is consider that if there is no human intervention, there's no copyright at all? Challenging question.
It is very challenging, Javier. I think that a lot depends on the theoretical framing of your question, in the sense, what do we want to achieve? What is our goal? To regulate markets, to steer the technological sector, to save creators if they need to be saved, to develop a model of governance for AI by creating, allocating property rights in a way that they create a specific sets of incentives in one way or in the other. And I think these are very valid and open questions to which I'm not sure I have honestly the answer. But I do think that at least if we look at how current copyright rules applied, with the obvious differences between legal system and legal system, there is, at least in theoretical, in more general terms, then I would agree with you that the problem would be at the moment of applying this general framework to our specific case. So what kind of evidence, how to prove the sufficient quantity of human intervention. But once again, if the prompt in itself is enough to capture in the EU, we would say the author's own intellectual creation, that is demonstrated by free and creative choices, whereby the author was able to stamp, their personality, which is more or less the standard that we have. Well, then the prompt, it is copyright protected, and we could argue that whatever we receive, depending on what it is, so the output of the generative AI application that has processed this prompt could be perhaps either a copy in part or a derivative work of that prompt, or even a joint work in certain cases. However, I still see this eventuality as a bit remote. I think that the large majority of situations are those where you simply type, show me a cute kitten, or show me a football player, throwing the ball as if it was both Messi and Ronaldo together. I don't know,
Right. Yeah, I understand. Yeah.
To me, these are very, very, basic requests. But I can see the opportunity and the possibility for requests that embed creative choices. But even in that case, and I repeat, probably the real difficulty here will reside in the evidence, in the proof. But even in those cases, I think that to the extent to which we can prove the element, the humanly input element, so the input data in this case, so the data that you enter in the APIs, in the website that allows you to interact with the AI application, and you compare it with the output, and there is a similarity, and there is access, or there is an element of derivation, we have doctrines that that address these issues. I think that Professor Hugenholtz, in one of his recent writings, speaks of human causality in order to identify the element that should distinguish, that should help us guide in our determination of whether there has been enough human intervention in order to grant authorship to that to the output that is at least in part a function not only of the training data but also of the input data. The proof may be something that the court will wrestle for a bit, but I think that the theory, in broad terms, probably it's very similar to what I said.
Yeah, wonderful. Yeah, human causality. I like that. Yeah, Carmelo, what do you think?
I think that I'm not a big fan of magic numbers or a specific length of prompts or a specific structure and requiring a baseline that would separate what is copyrightable and what is not, what is a work of art and what is not. I don't think that's how it should work. I don't think how we should look at the technology. You were mentioning LLMs, large language models, but general adversarial networks, they operate in a slightly different way. You provide different kinds of input that would have a different effect on the ultimate output. If I could use another example coming from the history of art, there is an Italian painter. I will call him a painter. Is called Lucio Fontana. He's got the same surname as myself. Some of his most prominent masterpieces were just some cuts that he would draw in the canvas, and then he would call them space or spatial. I don't know if you're familiar with his art.
Yes.
I think again, is not so much the way in which you would produce the output and the details of the human intervention, but the fact that there is an intention to create a specific output. And if you put that kind of rationale that has been used for art, for figurative art, into this new context of adopting technology, you were recalling the different ways in which you would weight and contrast and compare human intervention, selection of data, or the prompts, or the selection of the output, or the intention of the artist. I think as the technology is going to evolve and is going to amplify the reach of human action, a lot of emphasis should be given to what was the original intention of the author, of the artist that has created the output, and that would be something that courts, in being the judge of the facts, they would need to establish.
Mm-hmm. Right. Yeah. Well, I think that in a certain way, and because of some attempts such as the one of Davos, etc., where you try simply and to make an AI be considered as author, that we are currently in a situation that is more or less yes or no, right? And this could have an impact on that type of let's say new creations. And in the past, the copyright has found solutions or has been able to grant rights to people that were no authors, to be an artist or the owner of a database, etc., etc., etc. Do you think that we have to create a new category within the copyright? It's just an opinion, okay? It's not. It's just this. Do we have to create something that's special for this type of creations that are using artificial intelligence, either prompts or other type of tools?
I've seen many proposal, or at least some proposal in this sense, especially in the field of related rights. It is possible, technically it is possible. I wonder why. I mean, again, what are we trying to achieve? Why should we? Because, one of the, again, we should distinguish between legal system and legal tradition, because there are different underlying motives that may be more historical, but that still have an impact on the views of the courts and of the legislators. But if copyright, as it is in continental Europe, is a form to protect the personality of the author, or as if it is in common law countries, at least those that embrace a more utilitarian approach, a form to reach an optimal production of a certain good, knowledge, well, I am not sure whether allocating property rights to AI generated works will reach in any way or influence in a positive way these goals. It's true that there are certain legal systems, as a friend of mine who is attending this call just reminded me, that follow strictly the UK copyright design and patent act approach. My friend is Tobias Schoenvetter from South Africa, but that applies to South Africa and to a few other countries that have a specific provision on computer-generated works, and the provision allocates the rights in the person who makes the necessary arrangements. Assuming that this applies to AI, to AI generated outputs, this could be in part an answer to your question, Javier. So in this case, it would be copyright, not a related right, but it would be a form to allocate these rights. The only thing I will add is that in a recent study that we have conducted for the European Commission in a Horizon 2020 project called Recreating Europe, some colleagues have looked specifically into this in the UK environment, so the analysis was limited to the UK. And what we noticed, and my colleague noticed, was that it was a category that was almost never used. The reason we haven't explored it in detail, it might be because until very recently the UK was a part of the EU, and therefore probably that provision would not have been compatible with the case law of the Court of Justice on originality, whereas now it might. So it could be a category that will become successful in the future. But to the extent to which the UK is a representative example, it doesn't seem that there was a need to offer protection to computer-generated works.
Yeah, that's why they kept the article of law as it was, because they conducted a search in the UK and they said, well, do not enter in this discussion for the time being. Has been criticized because the British solution is whether or not this is compliant with Berne Convention. But, well, who knows? Carmelo, what do you think?
Yeah, again, I appreciate that if I were to disagree with Thomas, it would make for a more interesting conversation. But I have to
do it. Yeah.
I have to say that I do agree. Just to move a little bit the focus, if you look at how the draft for the Artificial Intelligence Act is trying to construe what's the value chain and the relationship between the different players at the different step of the way, between the creation of the service, the deployer, the programmer, the end user. You have a lot of people that would access this technology, would be extracting value from it. I think that the economics of this market are still in flux, and we do not know exactly how platforms offering these services will be supporting themselves. But we may find that a subscription model with millions of customers that are paying a few euros every month is a sustainable way of supporting this technology, and then since they're efficient for their cost structure and revenue structure, shifting onto the user the rights, the exclusive rights from their creativity or their work product is a more sustainable way of achieving our ultimate purpose, which, as Thomas was saying, could be incentivizing creation, protecting culture, distributing social welfare across society in a way that is fair. The difference, the big difference between what happened with press and copyright, it took I don't know how many centuries between when press was invented and then copyright, and what's happening now with these technologies that is moving way faster. But the scale of these platforms and the global proportion of these technologies is definitely posing different questions, and the economics again are so different that maybe copyright or a new bespoke right is not the necessarily the right answer.
Okay. If you want someone to disagree, I can do it, but no, I will not do it because I'm the moderator today. But let's say that you mentioned, Thomas, that there's a philosophical question behind this, and it's true. I mean, at a certain moment when the print was created, we had the same system, but then in the 19th century or the 18th century, it would be, yeah, when the Victor Hugo, Balzac, and others created the Société des gens des lettres, and there was a new conception of the copyright. I mean, the droit d'auteur system. They shift to a way in which the copyright or the authorship rights were the result of the human creativity. So this has created the current situation we're facing, and maybe that's why we have this distinction between solutions such as the UK one and others that are coming from other places. And well, there could be some influence in the final result of the business, but let's talk about this at the end of the encounter. Okay, why don't we shift to another issue, that is infringement. Okay. Do the LLMs infringe the rights of third parties when they are trained, when they are used? Where is the liabilities, the responsibility of the machine, the users, both, etc.? Let's start by the beginning. I mean,
sorry.
No, Thomas, I know that you have studied this in depth, so I would like to know your opinion because you have worked in this phase of training the machines. Right. So
yes, I
what
did.
do you think?
And I think that if we want to save authors, if we want to save the creative process, if we want to make sure that AI doesn't poses a threat to traditional business models based in the creative industries, which are key industries in many areas of the world, not only in Europe, probably the right, let's say, entry point, much more than the protection of the output, is to look at the input. The output is the end of the value chain, and it may or may not follow certain rules, but these rules are probably consequential to what happens at the beginning of it. To put it very briefly, I think that in Europe, we have, as we all know, two new text and data mining exceptions that have, by now, I think, implemented in almost all member states. Some other member states still already had some text and data mining exceptions based on the Article 538, so the exception for non-commercial research. And then there's the mandatory 5.1, so temporary copies, which has been also used for data extraction and retrieval processes, and it has been also litigated in front of the Court of Justice. And especially for the text and data mining exceptions, I think, again, two arguments here. Practical one, I'm happy to see them because they create clarity in a field that was extremely uncertain. And uncertainty, we know that impacts negatively much more individuals, small enterprises, authors, research organizations than big companies. If you are a very big company, if you are, Meta, Microsoft, Google, you have the resources to bear legal uncertainty. If you're an individual, there is a chilling effect, you just shy away. So I am happy to see these exceptions for this reason, and they have some good elements, such as, for example, the right to retain copies for verifiability. This is a much more research and public policy oriented goal rather than a traditional copyright goal. Copyright doesn't have reproducibility as its main goal, and yet we are happy to see it there. On a more, again, general theory level, however, I think that at least when they were approved, I've been quite critical to them, because by creating an exception, we are essentially saying that outside the perimeter of this exception, there is an economic right of right holders to train models, right? Because if there wasn't, we wouldn't need an exception to do that activity. So by creating a space of exemption, we are implicitly saying that training a model probably is a copyright-covered activity. Now, I have been imprecise. I said training a model instead of text and data mining. And the reason I've been imprecise is because we give for granted that they are the same thing, and they are treated in the same way by the text and data mining exception, because the definition is so broad that for a number of reasons that for brevity I won't list, but I'm happy to discuss, they also cover most likely generative AI. However, there is, in my opinion, an essential difference between a basic analytical technique essential for research, text and data mining, the possibility to mine the data of flight radar and being able to predict before anyone else the spread of an epidemic. This is an activity that has nothing to do with copyright and should not be regulated by copyright. A completely different thing is to have a technology that is able to produce perfect market substitutes of works of authorship, often the same works that were used for training. So in this case, I have much less of a problem in recognizing that authors should be able, through copyright, to regulate and limit and license and monetize or simply forbid that activity. Now, surprisingly, at this point, Article 4, so the text and data mining exception for general purposes that allows an opt-out for authors, becomes incredibly valuable, because it empowers authors to decide whether they want or they want not to be mined, and therefore their works used for training purposes. This is happening now. The technology is slowly developing. Maybe Carmelo knows more. I know of a couple of instances of groups such as Spawning AI trying to develop an AI.txt file in the same way that more or less the old robot.txt would have allowed search engines to scan websites. But if we do this, then we are able to, give author the possibility to decide that what they want to do. Some authors don't care. There are these situations. There are many. But some authors reasonably want to forbid their works to be used for training, because they see the work as really an emanation of their personality, and therefore it's an important relationship that needs to be protected. Some other authors may want to be remunerated for that activity. This is a good thing, but shouldn't. So paradoxically, and I end, we have text and data mining exception that I think are not very well suited for text and data mining, but suddenly become quite interesting for generative AI uses.
Mm-hmm. Right, Carmelo.
Yes, so it's serendipitous, I would say, that these provision Article 4 essentially became technology agnostic, because he ended up or future proof, like they say at the commission sometimes, because he ended up protecting for applications that were not directly related with text and data mining. But it goes without saying that once you have mined this information, you would put it to work, and so it would become part of be operationalized within a system. The challenge it is the standardization, because if you have an opt-out mechanism that is that needs to be handled, I don't know, through individual correspondence or individual applications, it would become unworkable, useless, burdensome for the platforms that would need to opt out and to observe and honor the decision of the right holder. So this is I think a very important issue, and I know, as a matter of fact, that big platforms are working to find a solution to allow a tool that would make opt-outs election effective and relevant for the owner. And then I think the other issue for which I don't have a good answer. I don't think there is really a good answer. Is that after the text had been mined and used, under the umbrella of the exception, has been used with a lot of other data, information, text, and has become part of a service, of a system, of an algorithm that has done its learning. So he has sort of extracted the wisdom that was part of that source. How you really take it out? There is no good way. There is no possible way to do it, because I can tell you a good joke, and then I ask you to forget it, and I'm sure you're gonna laugh again. That's what really happens when you learn and how the technology operates. So before you would be actually able to take out of the algorithm the information that was injected following an opt-out, you would need to either reset, launch a new version, or actively introduce a removal. It would be very costly and mostly ineffective, and I'm not sure it would really achieve what would be the desired effect of the right holder. And this is another question that I think big platforms will need to be looking into in the future.
Mm-hmm. So,
Carmelo, can I ask you a question? Sorry, Javier. Am I allowed to ask?
Go ahead.
So I steal your role, and then you can then disagree with us, and you become a speaker. So I remember having a conversation some times ago, and it is along the lines you just said, Carmelo. There's no way to so let's say that a model is found to be infringing because it has used without authorization a certain database or work for training. Damages, but especially injunctive relief. Remove it. There is no way. So the only way would be to retrain the entire model without that specific infringing work, which would have not only economic, but also vast environmental costs. We know how much time and money, but also how much energy these large language models are consuming. Which is one of the reasons why we only really have a handful of them. Only really large platforms are able to have the vertical integration that allows them to make these efforts. So how do we get out there? Maybe Carmelo or also you, Javier, have an answer, because to me this is one of the hardest points to understand. Generative AI is copyright or is governance of other aspect of our life? Because I always had the feeling that these two objectives will collide. Either we give injunctive relief to authors and you have to retrain the model with the consequences that we mentioned, or we don't. But in that case, assuming that there is copyright protection, we are denying a property right to its author.
It's a nice question. You're talking about proportionality.
Yeah.
It's an issue of intellectual property in general. Yeah, Carmelo.
No, I agree. It's a matter of proportionality, and maybe once you have pursued damages and you got an award that would be remunerative of your author's right, expecting also an injunctive relief, that will be also affecting the rights of other people, because there are other people who actually wanted their platform to be trained with their data, and maybe the data is not recoverable anymore. It will not be in the best interest of society at large, as you were putting it, the governance of the ultimate effect of this technology. And then, again, the fact that piece of information contributed to the training of the algorithm, and the fact that the piece of information is copyrightable does not necessarily mean that it's going to surface in a relevant, significant way to be tantamount to a copyright infringement, ultimately. It's a complicated question, and I think as the technology becomes more mature, we should be able to strike the right balance, and the jurisprudence will find a solution to make sure authors' rights will be respected, but the rest of the stakeholders is not just the platform. There are a lot of other people that are using it. The users, the other authors, is a complex scenario, and everybody should not be prejudiced by this.
Yeah. That's it. It is. I mean, if I can add something, I would say, well, that's funny. It's fantastic. Proportionality is a rule that has to be followed, but in a certain way, the rights of the author have been infringed, and then you say that there are environmental issues. If I have to disagree, I promise you that I can disagree. So there's a disagreement here. What are you talking about? I mean, I am the author. You have used my work, and now you say that because of environmental reasons, my rights are not respected. There is no answer for this. I mean, we will have many discussions about this issue.
That's the question. I think is a question of copyright, or a certain role that copyright has played historically, and an additional role that we, for some reason, want to attribute to copyright, and it is a role of regulating technology. But what I argue in most of my recent work, this is not something that copyright can do or can do alone. The role of AI governance should be external to copyright, because otherwise we risk to transform governance into an emanation of property rights. But we know from economic theory that the two are moved by a different set of reasons, incentives, policy objectives, etc. So to me, to use one to achieve the goals of the other is a mistake, is a technical mistake. For example, Article 28 of the AI Act, the European Parliament version, asks for generative AI models to developers to document and make publicly available a summary of training material when this training material is covered by copyright. Interesting, but is this a way to guarantee more transparency in AI? Because if it is, why only copyright material? Why not personal data? Why not other type of protected content? And if it is not, if it is only a way to, let's say, operationalize the opt-out, we can only charge if we know that we have been trained, and to go from the model to the training data is quite difficult to reverse engineer a model. Then we need to operationalize it, but then we kind of miss the goal of having as I said, a fair, transparent, replicable AI environment. So to me, that there is this mismatch that I see happening more and more, and I don't know. I'm not sure why it is happening. So maybe you have a better insight into this dynamic.
Right.
So
go ahead.
Yeah, on the Article 28, I think this rule makes sense in a closed environment. If you're training your data set on a library, on a closed database, where the data identifying the specific copyrighted works are reliable, it will make sense, could be operationalized, and possibly it will be a way to ensure transparency. When you're really working on a larger scale, and your source of text and data mining is the entire internet, the burden of identifying the details of each work would be impossible. You would need to know whether or not a web page is containing copyright or personal data, or what kind of other protected right, and then you would need to identify the author, or whether or not there is a licensee, and whether or not the license is expired, and it would become a mess. So on top, there are big trade secrets issues there that could not be discounted, because once you have to identify with transparency all of these details about your training training data and the algorithm and the approach, maybe you end up disclosing to your competitors more than you would need to. Yes, I am somewhat critical of this provision, which, by the way, was not included in the Commission nor the Council version of the AI Act. And I think it's easy to imagine why it ended up there. I'm not sure how it would work, unless, as I said, we're talking about some specific bespoke platform that has been trained on licensed data, licensed libraries. If you're relying on text and data mining exception, and then you want to identify the rights, it would sort of frustrate the entire purpose of why we have the exception.
Mm-hmm. Yeah.
Even though technically the exception contains also a storage and archival provision. So, in theory, there is a thin, but there is a red line that connects the storage that research organizations or commercial miners can do, because it's a copyright provision. It's not a rule on AI governance. But, if there is this copy and you need to disclose it, well, maybe there are possibilities to have access to that information in a way that, to a certain extent, guarantee more transparency than what we have absurdly for high-risk AI, because generative AI and foundation models are classified as non-high risk and yet have more transparency obligations due to copyright reasons than high-risk AI.
But yeah, but in a way, how is that different from what is happening in a regular hosting scenario? You go there and you claim that you are the owner of this piece of copyright, and you show your title or a sample of your work. The platform would check whether or not that exists in their hosting activities, and if there is any infringing behavior or occurrence, then they would have an obligation to remove it expeditiously.
Well, interesting discussion, but we only have some 5 minutes, I believe. So let's talk about something else. Oh, there's something that you mentioned, Thomas, I think, and that I've heard just yesterday in another meeting at IE Law School. That is the use of the Data Act as a tool for the creation of a community of data that would include also this type of data. I mean, I'm very well accustomed to the creation of communities to share technical data about how the machines work, etc., etc. And it's a movement there that are communities created even before the enactment of the Data Act. And someone talked about that, and it was exactly the same thing that you mentioned in the preparatory meeting, Thomas. That is the possibility of creating communities of data where it can be used by one or another to obtain different outputs, and without any concern about the possibility of being sued or things like that. What do you think?
Yeah, I think absolutely. In the language of the Commission, I think these are called Common European Data Spaces. It is a quite, strategic investment and project of the current Commission. There are already, if I remember correctly, 10 vertically identified data spaces, so sectorial, mobility, circular economy, but also cultural heritage, open science, smart cities, health data spaces, etc. And one of the goals, and this concept relies on some of the legislation that you have correctly mentioned, Javier. So the Data Act, but also the Data Governance Act, the Open Data Directive. We could even think of the older free flow, non-personal data regulation, et cetera, et cetera. I think that once again, this is a very ambitious project of creating the market infrastructural and regulatory conditions for a data ecosystem to emerge. One where there is more, one that embeds the EU core values. I think this is a very central concepts of the EU policy documents in this area. So to create a model of data governance, and if AI, at least modern AI, can only exist thanks to data, to regulate data is to regulate AI, or in any way to influence very heavily the ways in which it can be regulated, in a way that removes those kind of incentives that property rights would allocate. In one of my papers, I speak of a transition from a property-based approach to a governance-based approach in the field of data. The Data Act creates for non-personal data rights that so far we only seen in the field of non-personal, of personal data. Think of a right to portability. So the possibility to tell the manufacturer of the IoT product that not only I have to have access to it, but that you have to transfer that data to another player, even a commercial player, even potentially a competitor, as long as it is not a direct competitor for that product, for reasons such as right to repair, consumer freedom, avoidance of a lock-in phenomena, etc., etc. But this is just an example. If you take the Open Data Directive that creates almost a taxonomy of public sector bodies' data that have to be made reusable in various ways, one of the reasons that the recital clearly identifies is to create a set of high quality data. And I think this is a crucial aspect for AI training, not necessarily quantity of data, but quality of data available to all. Because obviously, if we need to pay to have access to this data, once again, big platforms are in a competitive advantage because they have much more money, but also they already have this data. Think of all the data that Google, Facebook, Microsoft, all the big platforms already possess. If we do this, we are simply, creating even stronger regulatory frameworks for already highly vertically integrated companies to remain even to enforce even stronger their position. Maybe this is an argument where we could disagree, Carmelo. And this is funny because a lot of this legislation, DSA, DMA, is really intended, even the corporate is a single market, think of Article 17, to regulate, almost to punish these platforms for their, dominant position in these markets. So it's funny to see that on the one hand, you want to limit their dominance, but on the other hand, by misusing once again copyright, you are kind of bringing back through the window the thing that you were trying to take away.
Carmelo, you can be silent if you wish, or you can intervene.
I'll be silent. We're almost over time.
Right. Yeah. I understand. No, there is a big debate on this, and it will continue. To find the balance here is very difficult. It's very difficult. And something that concerns me a lot is where we try to find out a solution. Well, we have opened the floor to data, to other issues, etc. My big concern here is that we only have a common framework that is copyright, the Berne Convention. If we try to find out solutions outside the Berne Convention, we will face problems because the national legislations are not sufficiently harmonized in other fields of property, let's say, and this will create more tensions. But my friends, I'm so sorry, but we are out of time. There are three questions that are, let's give the possibility to answer the questions. One of our participants says that I believe that the slow process of extending protection to photography under copyright or neighboring rights is probably a good analogy here. Could be, yeah.
Yeah, it could be. It could be. I think that generative AI has, especially generative AI, has some additional features. So photograph is almost a still recording of something that you have already in nature, which with time has evolved into a proper art.
Yeah.
And I see an element of similarity with what we discussed.
Yeah.
But generative AI has a much more interactive and almost creative role. And this is the element of discontinuity.
Yeah, but at the beginning, it was not so evident. I mean, when the photography started, many people say, well, this is not a painting. This is not art. It's just a reproduction of something that is in nature. There's nothing of authorship here. And thank you for the question, because, yes, it illustrates us how the moment in which we are analyzing one thing may change the point of view, and depending on the status of this art, this new art, can change the things. And another question.
Sorry, I just posted a link. It's something actually a friend of mine wrote. It's about a case in Italy. The Court of Cassation, the Supreme Court, decided that the use of AI to generate a fractal design based on some floral representation would not per se exclude the extension copyright to protect that work. And that is in line with what you were discussing. The article is in English. If you're curious, you can take a look.
Wonderful. Thank you, Carmelo. Last question. Another participant says, well, talking about balanced intellectual property right, as any property right is limited. In Spain, we have the usus innocui. It's something similar to fair use, that establishes limitation on property rights. Property rights is not absolute. Yes, you're right. This was already used by the Spanish Supreme Court to apply this fair use balance in a case of web scraping of a website in Google. And well, it's a good contribution. The question is so long, and we do not have enough time, but we will include in the report. Okay, and it insists on the questions of the fair use and the principles of law, etc. Thank you very much for your contribution. And I think that we are some 3, 4, 5 minutes ahead, so we'll close now the discussion. Thank you very much to you, Thomas and Carmelo, for this fruitful discussion. And I give the floor to Manuel DESANTES to close the meeting. Thank you.
Thanks, dear Javier. You were brilliant, my dear. We're very proud of you. So what an exciting topic here. As you three have highlighted, I get the feeling at the end of the discussion that our lives depend on the answers provided to your questions. What is amazing is to acknowledge how fast things go. I have the impression that 1 year ago, we probably have brought the discussion in a very different way. So my feeling, Laurent, is that we should devote many more encounters to this hot topic in the future. And that recollection from memory, you have dealt with so many topics that the first question brought immediately into the table whether there is any copyright in the LLM output. And the question of authorship, the Davos case, what the US Copyright Office had just decided some days ago. Then I recollect that we move to the question whether the LLM infringe the rights of third parties. The responsibility relies on the machine, on the users, or both. Recall that Thomas emphasized the value of the input over the output, and how the the generative artificial intelligence has, I should say, has exacerbated this question. Just to recollect you all, the discussion moved then to the questions whether we need an exception, for instance, similar to the text and data mining exception, and even I should say whether we need a complete special legal environment for the machines or not. Yeah. I don't want to go further, but just let me recollect, because it just comes to my mind, the question whether the protection within the framework of the copyright should be enough, or we should go through another means. I remember Thomas saying that generative AI is copyright, or it is governance of other aspects of our life. Yeah, and this is a very fundamental question for our reasoning in the future. Javier brought the proportionality. Also, you also brought the environmental consequences. How does this issue affect to third parties? I think it was Carmelo who brought it. What are the consequences in each case? Yeah. So I have the feeling, as a conclusion, that the whole historical role of copyright is now under very, very severe discussion. And what you have dealt with, the discussion on Article 28, probably clearly shows this matter. Yeah. We'll stop here because I don't want to reproduce the discussion, but just to bring the feeling that there was so extraordinary ammunition there. Very impressive indeed. Yeah, very impressive. Thank you. So there, Carmelo, and there, Thomas, we are very grateful to you both. Be welcome, Thomas, to the Encounters family. Thanks also for the very interesting questions. Unfortunately, this time there was no time for answering all of them in deep, but as Javier said, we promised to bring them in the report. Yeah, and they will be answered if you feel like Carmelo, Thomas, and Javier. They will be answered for you, and the questions will be brought to the report. This time, the report will be drafted by Xiao Baiyang from China and by Tu Uhta from Finland. So thanks also to you both. I would like to insist again and again that the reports have become a precious instrument for researchers and for professionals. They are used so many hundreds of times by so many people, also for students. Yeah, and you know, the Encounter Support Group has already provided to you almost 30 splendid reports. Yeah, I would like to recall also that the support group contains young scholars from more than 16 nationalities. Yeah. So finally, thanks also, as always, to Alvaro and to Blanca, and of course, many thanks to all of you that have been here with us today, for being so patient and for being so loyal to the Encounters. Take care and join us in 1 month for our next encounter. The 30. This encounter will take place on the 18th of October. Take note already, and we will bring to your attention another very, very, very exciting topic: the IP implications of the data economy. As always, we will have brilliant speakers, and we will prepare splendid materials and references for you. So enjoy the rest of the day. And thanks for being here with us today. Bye-bye.
Bye-bye. Thank you.
Bye-bye. See you in October.